Good afternoon, everyone, and welcome to our seminar this afternoon entitled What Just Happened? The UK's New Deal with the EU. So if we begin, I mentioned that the session is called What Just Happened. That's something that we could have picked as a title for quite a lot of what's gone on in the last year, but we're particularly looking at the UK's deal with the EU. And the speakers today, and sorry, I will go back one to our speakers to introduce myself, Christine O'Neill. I'm the chairman of Brodie's, and Charles Livingston, my partner. Many of you will know us if you have been to our Brexit seminars before, and we're sorry that we're not looking at you in a more live environment, but we are back for perhaps one more outing on the topic of Brexit. We're both partners in the government regulation and competition team and hope to be of some use to you this afternoon. So if we begin by reminding ourselves of just exactly where we got to and how we got there, it feels perhaps a bit like ancient history now, but on the 29th of March 2017, the then Prime Minister, Mrs May, gave notice of the UK's intention to leave the EU. An awful lot happened after that, and if we move on, you may also remember this. This was a time when you could go walking in the garden with someone and not worry about whether you were 2 metres apart from them. And this was in October 2019, when you may remember that the Prime Minister and the then Prime Minister of Ireland, Leo Varadkar, got together to try to solve the problem that was standing in the way of the UK and the EU reaching a final withdrawal agreement to allow or to enable the UK to leave the EU in an orderly way. And that resulted in an agreement about the withdrawal agreement, and we will come back to that shortly. And if we move on, we got to that agreement in October 2019 that made provision for the UK to leave the EU at 11 o'clock UK time on Friday the 31st of January 2020, and we did so leave. That withdrawal agreement provided for a status quo transition period until 11 o'clock on the 31st of December 2020, and that withdrawal agreement remains important, notwithstanding the end of the transition period, because that withdrawal agreement made provision for EU citizens in the UK and indeed for UK citizens in the EU, and what would happen to them so long as they arrived before the end of the transition period. It also made provision for special arrangements relating to Northern Ireland after transition, so beginning on the 1st of January this year. We know that those special arrangements were the subject of some controversy at the end of 2020, when there was a suggestion that the UK government might seek to depart from that agreement, but ultimately decided not to do so. And we'll talk a little bit about the impact of that. And the agreement also dealt with the money side of things, the basis on which the UK was leaving the EU. And then we move on to finally remembering this when we did have social distancing, and this was near the end of the negotiations between the UK and the EU, not on the withdrawal agreement, but on the future relationship between the EU and the UK. And that's going to be the focus of the rest of this session. And what I should say about this seminar is that we are deliberately giving you a high-level overview of the UK-EU deal, and that's for a number of reasons. The first is that it's a very, very, very long agreement, and as you will come to see, in fact, it's 3 agreements, but there's an awful lot of material, so we couldn't possibly cover all of it in one seminar. The other reason that we're going to be giving an overview is that Charles and I are only equipped to be superficial about much of what is in the EU-UK deal, and that's because very much of the material in the agreements relates to very specific areas of industry, sector-specific issues, Where we are not the experts in roadies, we have colleagues around us who are expert in questions of food and drink labelling, in issues of taxation and VAT, in issues of medical devices and product liability, in transport and in other areas. So we don't purport to be the experts on all of these areas, but we aim to give you some helpful information and a direction to the people who are the experts if further information is required. The other thing I just want to say at this stage is that Charles and I are going to be looking at this from the perspective of lawyers reading a legal agreement and trying to think about how that might impact you in practice. But for a more practical look at the impact so far of these arrangements, we will be inviting you to join us again on the 18th of February, and we'll give you a link to this at the end of the seminar, for a discussion we're having at 12 o'clock on the 18th of February with Liam Smith, who's the Director for Trade Facilitation with the British Chambers of Commerce, and with James Withers, who is the Chief Executive of Scotland Food and Drink. So they will be talking to us about the practical effect of the arrangements that we're going to describe in a little bit more detail today. So if we move on, where we are now is that we have, as of the end of last year, 3 agreements between the UK and the European Union. The main agreement, which you may have heard of, is the Trade and Cooperation Agreement, which runs to a whopping 1,246 pages. It's accompanied by a nuclear cooperation agreement, which is very short and effectively replaces Britain's membership of Euratom, which was the European organisation on nuclear cooperation, not nuclear weapons, I hesitate to emphasise, but nuclear energy. And then there is a short agreement on procedures for exchanging and protecting classified information. So the Trade and Cooperation Agreement is undoubtedly the key agreement from the perspective of the EU and the UK. That agreement has been given effect in British law by the European Union Future Relationship Act of 2020, passed at the 11th hour at the end of the year. We shouldn't forget, and I'm sure you would never forget, that we also have, amongst all the other legislation about Brexit that's on the statute books, we have the European Union Withdrawal Act of 2018. And the purpose of that act was to ensure that when we left the European Union and we got to the end of the implementation period, that we didn't lose all of the European Union law that we've been relying on in the UK for the last 40 years. So the Withdrawal Act of 2018 retains EU law as part of UK law until and unless positive steps are taken in the UK to change that law. There is a parallel bill which was passed also by the Scottish Parliament at the end of the year, which has not quite received royal assent, but that's expected very soon, which makes some similar and specific provisions for Scotland. And finally, just to remind you again of other things that have been happening, but which are related to the deal between the UK and the EU, we have the United Kingdom Internal Market Act of 2020. And the purpose of that act, amongst other things, is to try to replicate within the UK the kinds of rules on freedom of movement of goods, in particular, that were part of the EU legal order that prevented the UK from discriminating against goods from other parts of the EU. Similarly, the Internal Market Act of 2020 is to, on one view, attempt to ensure that the different jurisdictions within the United Kingdom cannot discriminate in that kind of way against goods made in and coming from other parts of the UK. So we have this suite of agreements and legislation, and we're going to pick up on just some of the provisions that have been made by the Trade and Cooperation Agreement in some of the sectors affected. As I say, we won't cover all of them, but we have taken some of the particular issues we think may be of interest to you. And I'm going to start on those by handing over to Charles, who's going to talk about trade.
Thanks, Christine. Obviously, trade and cooperation agreement, the clue is in the name. A lot of what the agreement is concerned with has to do with trade. The principal takeaway, and you will have heard this touted, is that the agreement means there are no tariffs or quotas on UK goods exported to the EU. Or vice versa. That is reportedly unprecedented for the EU to agree to a deal that has no tariffs or quotas. So as EU free trade agreements go, that aspect of it is pretty significant. I have used the phrase UK goods advisedly, though, because it's not the case that all goods that happen to be moving from the UK to the EU or in the other direction are free of tariffs. The question therefore arises, what are UK goods? Because it's UK goods that can go tariff-free. And in order to establish that, you have to consider rules of origin. Now, these are it's a standard principle and practice in free trade agreements. Essentially, rules of origin are there to establish that only the goods that originate in the country that's party to the free trade agreement get the benefit of the tariff-free trade. An example that I've used for quite a few years now of why that's important. Norway is not within the EU's customs union, but it is part of the EEA, so it has tariff-free trade with the EU. But because it's not in the customs union, it has separate tariffs from the EU. And in particular, it had much lower tariffs on Chinese garlic than the EU did. And as a result, there was a great deal of smuggling of Chinese garlic, which was being imported into Norway, paying the lower Norwegian tariff, and then being smuggled across the border into Sweden and into the EU. So that's why you need rules of origin, so that the tariff-free arrangements only apply to those goods to which they are supposed to apply. Now, the rules of origin provisions in the UK-EU agreement are relatively liberal as these things go, but they are still massively complex. There is essentially a different rule of origin for every conceivable type of product. So if you make a product or export a product or buy a product, you will be able to identify the rule of origin for that particular product. And they vary in the criteria on which they depend. So in some cases, it will be a percentage amount of quote unquote local content. So it might be that something, a car that's assembled in the UK, so 55% of the parts need to be UK. If 50% of the parts are in fact Japanese, then it's not treated as a UK car and it's not eligible for the tariffs. Sometimes it's a percentage, sometimes it's what's been done to the goods. So for example, you can import cloth from a third country. If you then just try to sell the cloth onto the EU, you'll pay tariffs on that. But if you turn the cloth into a shirt, then that shirt will be a UK good and will be eligible for tariff-free trade. So that's a high-level overview of rules of origin. It's not really possible to get more into the weeds than that, because by and large, rules of origin is all weeds, just depending on what the product is. So if it's something you're not sure about, then you will be able to track it down or get someone to help you track it down. Key within that concept is the principle of cumulation, and I can illustrate that in terms of UK-EU trade. I mentioned a car, so if you have a 55% threshold for UK content, as part of the FTA between the UK and the EU, any goods that have been brought into the UK from the EU and then assembled into that car will count towards that UK content threshold. So that's called cumulation. If a good comes in from the EU and is then worked into the UK product, it will count as UK origin, and so count towards that threshold. You do have to do something, generally do have to do something to what you've imported from the EU before it can go back out again tariff-free. You'll no doubt have seen the Percy Pig story in terms of Marks and Spencer bringing in their Percy Pigs from continental Europe, repackaging them in the UK and then attempting to send them out to their stores in the Republic of Ireland, so back into the EU. And the issue there is that those don't qualify as UK goods, because simply taking something from one package and putting it into another is not sufficient working to make it into a UK good. It's also not registered as, it doesn't register as an EU good under the system either, so there's a tariff issue there. I think the view seems to be that that was potentially overlooked, given the rush with which the agreement was drafted. It may be fixed, it may not be fixed, but it's an example of how rules of origin and accumulation can be particularly complex. I won't spend too much time on this next point. I've been chastised by Christine for doing that in the past. But the concept of accumulation of third country goods, it's called diagonal accumulation if you want to Google it. The principle there is that if the UK and EU both have a free trade agreement with a country, say South Korea, then in principle you could have a diagonal accumulation arrangement where the South Korean goods are imported into the UK, worked into your UK manufactured car, and can then the EU would recognise those goods as UK content. The FTA does not have that accumulation. So prior to this year, those goods coming in from South Korea, they would come into the EU customs union of which the UK was a part. There wouldn't be a tariff payable because of the free trade agreement with South Korea. Once they're in the UK, they can then circulate freely throughout the rest of the EU. But now there's free trade with South Korea, but those South Korean goods will not count as UK content if a product is then sold on to the EU. So there's potentially significant disruption to supply chains there, and that if you're not sure of the impact of that on your supply chain, you should certainly be checking that. Just a practical matter. Rules of origin are very important if you need to avoid significant tariffs. They don't matter at all if there are no tariffs on the good that you make to begin with. So the EU doesn't place any tariffs on spirits, for example. So you don't need to go through the bureaucracy of establishing that your spirits are UK origin in order to benefit from tariff-free trade, because there are no tariffs to be paid. So you don't need the origin certificates. You don't need to do that working. You just send it into the EU. And it's tariff-free. For low tariffs, some businesses might just be taking the view that the cost of navigating the rules of origin is not really worth it in order to avoid a very low tariff. That may well be a rational position, I think, certainly to begin with, while they also deal with the other trade facilitation issues that I'll be mentioning. While they get to grips with that, it's probably rational. I think in the long term, businesses in that situation should be looking at how the tariff payments might accumulate over time, and if a little bit of short-term cost might deliver long-term gains in terms of trying to get within the rules of origin requirements. But they are particularly important for goods that attract high tariffs, and I'll come back to that in relation to food and drink later on, which is where the EU has some of its highest tariffs. Separately from tariffs and quotas, there's also the concept of technical barriers to trade, which is not you paying money to the UK or the EU in order to send your goods there. These are just sand in the gears, forms that have to be filled in, certifications that have to be obtained before goods can be sold in one jurisdiction or the other. The UK wanted mutual recognition of conformity assessments for things like manufactured goods, did not get it, so that mutual recognition does not exist. That means that if a product is certified as safe in the UK, it will have to be recertified as safe in the EU in order to be placed on the EU market, and vice versa in the long term, if not immediately. Christine mentioned the withdrawal agreement and the Northern Ireland arrangements earlier on. I think it's very important to specify that these types of barriers will generally apply to trade between Great Britain and Northern Ireland, as well as to Great Britain and EU. So a certification in Great Britain, that product may need to be recertified by either a Northern Irish qualified person or a qualified person in the EU in order for it to be placed on the Northern Irish market, because by and large, the withdrawal agreement committed Northern Ireland and committed the UK to ensuring that Northern Ireland follows EU rules on most of these issues in order to facilitate north-south trade on the island of Ireland. The agreement does provide for some streamlined regimes, although they don't remove these issues entirely, but they do make it simpler to establish conformity. And they're in medicinal products, which I'll return to, motor vehicles and equipment, organic products, wine and chemicals. The agreement, Trade and Cooperation Agreement, that is TCA, it encourages both parties to use international standards for conformity, but it permits deviation. In practice, anybody looking to sell in both areas will conform to the more burdensome regulatory position. So deviation is likely to have an effect on their competition with non-exported, non-traded products, rather than products from the other side of the agreement. The final bullet point there, I've mentioned that there's more leeway on the UK side in relation to these issues, things like conformity assessments. The UK is not bringing those in immediately. The EU is bringing those in immediately, so those rules are now a fact. On the UK side, there is more of a transition period. The length of it varies according to the product, which is why I've not put anything on the slide. But if you're in one of these affected sectors, I think you will know what the timings will be. So moving on from trade specifically to more sort of friction at the border types of issues, customs and VAT being the main ones. There is and has been since the start of January the new UK border operating model in place. That means that there are customs declarations and paperwork that have to be completed for trade between, again, Great Britain and the EU, or Great Britain and Northern Ireland. That's even if tariffs don't apply, you might need to certify your rules of origin status. Even if you're not claiming rules of origin, you might need to nevertheless fill in paperwork to establish and confirm the tariff position, and essentially to confirm what your products are that you are shipping to the EU or to Northern Ireland. On the GB side, and this will be a recurring theme, the new procedures have been staggered to allow parties more time to adjust. The EU has introduced their changes immediately. There are trusted trader schemes by which people can become an approved economic operator. That essentially is a form of fast tracking. You don't need to tick quite as many boxes or fill in quite as many forms. So if you are regularly importing or exporting, then it's certainly worth doing that. And that applies for non-EU trade as it does for EU trade. Great Britain, Northern Ireland trade in particular, there's a trader support service, which is a free service offered by or funded by the UK government to help with the form filling and try and reduce that burden and that cost for businesses trading between Britain and Northern Ireland as much as possible. Key to moving goods across borders now is the Economic Operator Registration and Identification Number, EORI number. Not previously required if you were only moving goods between the UK and the EU, but you would have had one if you were moving them outside the EU. If you are moving goods, you will almost certainly have a UK EORI number. One question that we encountered quite a lot in the second half of last year, and I think once or twice this year, is the need to have a UK number and an EU number if you are essentially sending goods to yourself in the other jurisdiction. So if you're part of a business that operates in both the UK and the EU, moving goods from the UK part of your business to the EU part or vice versa, you need an EORI number in both jurisdictions. A specific EORI number was introduced for Northern Ireland with the XI prefix. Every business with a UK EORI number was given an XI EORI number. So if you got one of those and you didn't know why, it's because everybody else was getting them too. And that, again, that's just to facilitate the Britain, Northern Ireland trade and try and reduce the burden on any given business to continue to do that. Concept of a duty deferment account essentially allows duty, VAT, tariff payments, etc. To be deferred and combined into single payments on a sort of regular schedule rather than for every consignment that needs to come in or go out. And I mentioned VAT, so import VAT is now payable on EU imports, and this is a big change. It's not a tariff, but it has some similar effects to tariffs in some respects. The UK has introduced postponed accounting, which means that businesses who are VAT registered can pay import VAT on their VAT returns rather than at the border. And that applies to all imports, not just EU ones. Businesses that are not VAT registered will still have to pay at the border, so that may be a relevant consideration for some in terms of deciding whether to be registered. This does mean increased compliance costs for businesses, and particularly, I think, for small businesses. You may have seen some of the stories about bike parts from the Netherlands and other businesses refusing or at least temporarily declining to send their goods to the UK. A particular reason for that is a rule that goods with a value of less than £135, even if they come from outside the UK, are treated as being a direct supply in the UK, which means the EU exporter has to register for UK VAT, and that's caused some objections within the EU and has resulted in a bit of disruption at that sort of smaller level of trade. So the next slide is more concerned with services than goods, services and investment. There's not very much in the agreement about these. It does establish some key principles, in particular relating to market access from one side's businesses to another. So the agreement commits each side to not introduce things like economic needs tests, quotas on the amount of foreign capital or foreign representation there can be on a board, restrictions on the corporate form of entities, things like that. It requires or it imposes non-discrimination, so a UK business should receive the same treatment as an EU business when it operates inside the EU. There's no establishment requirements, so you don't have to have a branch in order to operate in the EU. And there's also a most favoured nation agreement, which means that if either side cuts a deal with somebody else, that means that other parties' businesses get better treatment, then that automatically also extends to the UK or the EU, as the case may be. Not unlike rules of origin and what is a UK good, there's a question of what is a UK business for these purposes, and the agreement defines it as a business that has substantive operations in the UK. So it's not just about being incorporated, or it's not even about being incorporated in the UK. A company that's incorporated in the UK doesn't necessarily benefit from the agreement if it doesn't have substantive operations in the UK. And there are also issues on the other side. Jurisdictions like Germany, for example, will not necessarily recognise the corporate personality of a company that is registered in the UK, but has its quote-unquote real seat elsewhere. So that is something to be thinking about as well if you're in that situation. The agreement is probably actually more notable for the exceptions to these principles than it is for the principles themselves. So there are whole sectors to whom the principles doesn't apply, including aviation, telecoms, and financial services, where equivalence, mutual recognition is to be further discussed, and we'll see what happens with that. And we can move on there.
Thank you, and I will pick up, and I just remind everyone that they heard first the concept of diagonal cumulation on this webinar. So when it's been talked about in the 6 o'clock news, you will know that we talk of nothing else at Brodie's. So what's happened to data protection? There was concern running up to the end of the transition period that we wouldn't get an arrangement that allowed for the continued transfer of personal data between the UK and the EU. So just to see where we have got to with the agreement, if we start with within the UK, so inside the UK, we now have a concept called the UK Gdpr. That is the original EU GDPR, but amended to fit UK law, and that is the regime that governs the processing of personal data within the UK, and that's complemented by the Data Protection Act 2018, and read together they are now data protection law for the purposes of the United Kingdom. In terms of external transfers and imports of data, the UK is now a third country for the purposes of EU data protection law, and to that extent is in the same situation as, for example, the United States. So what that means is that the UK has to make a decision about whether it trusts the EU in terms of data protection law, and the EU has to make a decision about whether it trusts the UK in terms of data protection law. So for transfers of personal data out of the United Kingdom into the EU, the United Kingdom has made a finding of adequacy in relation to EU data protection law. It'd be quite hard for it not to do that, but it has decided that EU data protection law is sufficient to protect data going from the UK out into the EU. For transfers of data from the EU to the UK, the European Commission has not yet made an adequacy decision, and the absence of an adequacy decision could have had quite a significant impact on businesses in the UK who are engaged in the transfer of data cross-border. What we've got instead of an adequacy decision is a further transition period of 4 months from the 1st of January this year, with an option to extend that by a further 2 months. So a potential 6-month window during which transfers from the EEA to the UK are not to be treated as a transfer to a third party for the purposes of EU law. So effectively, we've got a 4-month, potentially 6-month standstill period when the old rules apply, and we can be treated as though we were effectively still within the EU for the purposes of transfers. That is helpful, but it's not guaranteed that the EU Commission will make an adequacy decision in favour of the UK, even within the timescale that we've got. We've got to hope that they will, but if they don't, and there is no adequacy decision, then there are going to be questions for EU-based data controllers sending personal data to the UK, because in the absence of an adequacy decision, they will need to rely on a combination of other measures, including standard contractual clauses, but not limited to standard commercial contractual clauses. I should mention that notwithstanding this transition period, dual regulation of data protection is already in force, and that means that if you are, for example, a business in the UK that's engaged in sending data or using personal data from within the UK, but also EU personal data, the personal data of EU citizens, you will have to think about your obligations under not only UK law, but under the law applying in the EU relating to regulation of personal data. I can't give you all of the detail about that here. I would recommend the blog post that I've given you a link to from my partner Martin Sloan. And if people have particular questions about data protection, then please do let us know. But meantime, we'll move on to free movement of workers and workers' rights. So the next slide, please. And again, just reminding you of where we got to under the 2019 Withdrawal Agreement, EU citizens and members of their families who were lawfully living in the UK before the end of last year have the right to carry on doing so, and the same applies to UK citizens lawfully living in the EU by the end of the transition period. However, for EU citizens in the UK, that is subject to the requirement for settled status. So the UK introduced a scheme in terms of which EU citizens who have the right to stay nevertheless should apply for settled status. And there is another group of EU citizens, frontier workers, who will need a frontier worker permit. And there are special rules in place for workers who are moving within corporate groups. So I suppose in some, just bear in mind that if you have EU nationals working with your business who were here before the end of last year, please do think about encouraging them to apply for settled status, and think about the implications for them if they're not able to secure settled status, and think about whether you have any frontier workers who will need a frontier worker permit. There is a grace period for many of these requirements until the 30th of June this year, and the settled status scheme is open for applications until that date. There have also been put in place as a result not of the 2019 agreement, but last year's agreement, reciprocal arrangements for short-term visa-free business travel between the EU and the UK. For non-EU nationals, and you may be aware of this, a new points-based immigration system came in from December of last year, and that will apply to new EU nationals from January this year. So those are the key points on workers' rights. Again, it's not an area of practice that Charles and I work in on a regular basis, but we have specialists in immigration and employment law who can assist if you have particular questions about workers' rights. That takes us, I think, back to you, Charles, for state aid.
Yep. So we thought we'd say something about state aid because it was obviously one of the big sticking points in the negotiations, and it's an area where there has been possibly more dramatic change than in most areas. So our starting point is that EU state aid law no longer applies in the UK. It has not been retained, to use the jargon under the legislation Christine mentioned earlier. That's again subject to special arrangements for Northern Ireland, where EU state aid rules still apply, and to some extent that may constrain what can be done in Great Britain to the extent that aid granted in Great Britain might have an effect on Northern Ireland. So we'll see how that plays out. But starting point is that EU state aid law no longer applies. However, the TCA does have a chapter on subsidy control. The words state aid don't appear, I think possibly for political reasons, but there is a chapter on subsidy control, and there are obligations on each side to limit what they do in terms of subsidies. Obviously, state aid law still applies in the EU, so this is largely a restraint on the UK side. These provisions are given effect in UK law by the EU Future Relationship Act 2020, which Christine mentioned. I say for now because I expect there will be something more specific to subsidy control coming out of UK Parliament in the near future. The UK government's guidance on this issue does not actually appear to concede that the Trade and Cooperation Agreement is directly binding, but I think for technical reasons I won't go into, the terms of the Future Relationship Act mean that they are actually enforceable as a matter of UK law via that Act of Parliament. So the principles and the exceptions are largely similar to EU state aid. I've bulleted some of the areas where they actually differ a bit more. In order for a subsidy to come under this chapter of the TCA, it has to affect trade and investment between the UK and the EU. Now in EU state aid law, a subsidy has to affect trade between member states, but the Court of Justice had set the bar for that so low that it's almost impossible to get under it. So that was almost a dead letter in terms of EU state aid law. There is, I think, probably much greater scope to argue that subsidies do not affect trade and investment between the UK and the EU, so much more scope for what you might call more local interventions. There is a higher de minimis level, so the de minimis rules in EU state aid law allow a business to receive €200,000 over a 3-year period. The agreement sets that at 350,000, so greater scope there. The block exemptions under EU state aid law no longer apply, so those set out principles where particular types of intervention or intervention in particular areas and sectors were generally automatically permitted without any clearance being required. We don't have any block exemptions anymore, but I think the block exemptions that used to apply and that still apply in the EU will at least be useful in assessing questions such as, will this subsidy affect trade between the UK and the EU? Will it be permitted on environmental grounds, which the TCA still recognises as a basis for subsidies? There are quite onerous transparency requirements for subsidies. They have to be published within 6 months on a sort of central register, so that's going to have to be set up, and the compliance costs of those might be quite considerable for public authorities. There are also fairly significant information rights in the agreement. So if a public authority gives a subsidy and anybody then asks it for information about that subsidy on the basis that they're thinking of challenging it, then the authority has to provide that information. That's new. That didn't exist under EU state aid law and could be, again, pretty onerous on public authorities and quite a powerful tool for anybody who's unhappy with a particular subsidy being awarded. The courts will still be able to order the repayment of unlawful subsidies, but damages may not necessarily be available anymore. We didn't get a lot of state aid litigation in the UK, although Christine and I have each done some. But that prospect of damages may mean that public authorities have less of a disincentive to award subsidy, given that the repayment risk tends to fall on the recipient. There will be quite strict time limits for challenging subsidies, generally 1 month from when a subsidy appears in the whatever the transparency mechanism is. So it will be important for people to monitor that if they're concerned about subsidies being given to their competitors, for example. And the agreement also commits both sides to having an independent regulator. The EU already has the Commission. It's TBC what it will be on the UK side. The CMA, Competition and Markets Authority, was being geared up for that when we thought state aid law was going to continue. My understanding is that it does not currently know whether it's going to be given that role. It may go elsewhere, but somebody is going to have it. So moving on to a few sector-specific points, just to touch on these quite lightly, touch on food and drink particularly lightly, because as Christine said, we've got a session coming up with James Withers, who will have lots to say on these issues. I mentioned before that there are often high tariffs on food and drink products, although spirits is an exception, 0 rated, but food, agricultural products in particular tend to have a high tariff. So rules of origin may be particularly important for the sector. Sometimes it'll be relatively simple. If you're looking to sell steaks, the question is, was the animal born, reared and slaughtered in the UK, but could be challenging for others. So for example, Caribbean sugar that is imported into the UK and refined here will not qualify as a UK good, nor will basmati rice from India that's milled in the UK. That's treated as insufficient work being done to the product to turn it into UK goods. So that combination of complex rules of origin and high tariffs means that food and drink sector is going to have to be particularly on its toes for these issues. Sanitary and phytosanitary standards, that's basically control of pests, disease, etc., means that products of plant and animal origin will be subject to strict controls, including at the border. They are subject to the strictest level of controls. They already have to comply with the VAT and customs arrangements, and they have these on top. It does mean that those products need to get things, or will often need to get things like health certificates before they can be exported. There have been issues with consignments where some of the products in a lorry have all their paperwork in order, other products don't, the lorry therefore doesn't get through, and even those whose paperwork was in order, their perishable product then rots before it gets to the end customer. So these are particularly key issues to navigate. The fishing sector in particular is having a really hard time with government systems not being up to scratch to facilitate these sorts of issues. Again, just to emphasize that these restrictions apply between Great Britain and Northern Ireland, but there are extra mitigations and grace periods there, so not quite as strict enforcement as between Great Britain and the EU. And these standards also apply to non-food products. So wooden pallets are obviously of plant origin. A particular concern has been that those now have to be heat treated if they're going to leave the UK's SPS zone and enter the EU's. And that there was certainly a concern about a significant shortage of wooden pallets as a result of that, and people trying to find workarounds. And that's the sort of thing that we'll cover in our next session with Liam Smith. Labelling. The EU rules require that prepackaged foods put on sale in the EU or indeed in Northern Ireland need to have on them the name and address in the EU or Northern Ireland of either the manufacturer if it's established there, or the person who imported the product into the EU or Northern Ireland. So a Great Britain address is no longer valid. This is one of the areas where we've had the most client interaction, most client concern. Those manufacturers based in Britain who don't have an EU or Northern Ireland office that they can put on there, we've been helping them navigate that issue, but that will, I think, run and run. It's not generally a border enforcement issue, it's more a sort of trading standards point of sale type concern. So it's yet to be seen how that is enforced. Somebody will probably be a test case. We're trying to help our clients avoid being that. It is going to be a two-way street, but as in other areas, the UK is being more generous than the EU and is deferring the equivalent requirement for EU goods until September 2022. Then briefly on life science issues. So the agreement permits mutual recognition of inspections of facilities where medicines, etc., are produced. That means they don't have to be inspected twice, which is a bonus. There are now two separate regulatory regimes for life sciences, and this is an example of the divergence that Christine mentioned. So there will be one regime in Great Britain and another regime that applies in the EU and Northern Ireland. Right now they're aligned, but they will be able to diverge. Interestingly, this is an example of the sort of divergence you might not necessarily have in mind, because the regime in Great Britain will largely remain based on existing EU legislation, and it's the EU that's going to go in a different direction by adopting its new regulatory framework. That's been in the works for a while. The UK basically decided not to adopt it, so you will see divergence there. Then in terms of additional hurdles, just some examples that illustrate where the sand can get into the gears. The EU will not recognise batch testing of medicines carried out in Great Britain, which means that each batch has to be certified by a qualified person in the EEA or Northern Ireland. And again, an asymmetrical grace period there. The UK will accept EU certifications in the short to medium term. There's no mutual recognition of medical device conformity assessments, but medical devices, as I said, those are one of the areas where producers are probably most used to navigating different regulatory requirements and pitching themselves at the strictest so that they can then also comply with all the others. So a UK conformity assessment was introduced at the start of the year, but again with a particularly long grace period. And medical devices will need to navigate rules of origin as well. How complicated that is for them really depends what they are and what they contain. So Christine, back to you for transport.
Yeah, and very briefly, our last slide. I think this is an example of some of the features of the UK EU agreement that apply in a lot of sectors, but in particular in relation to transport. There is an awful lot that is left for future development and future cooperation. So while the basics have been agreed, there is much still to be dealt with between the UK and the EU, and putting it at its very highest, the rules or the agreement between the EU and the UK allows for the basics. So in relation to aviation, planes will continue to fly. In relation to haulage, trucks will continue to travel from the UK to the EU and vice versa. And for shipping, there will be access to ports and port infrastructure and ancillary services. For each of these sectors, there is a framework for future cooperation, and for each of these sectors, there are situations in which the benefits that each sector has compared with what they had under membership of the EU is significantly diminished, and that's particularly the case in relation to cabotage, another phrase with which I was not particularly familiar before, but the notion of a lorry, for example, taking goods from the UK to the EU, and then on its way back making a number of stops within the EU, picking up and dropping off goods as it goes. Not an issue that was, of course, of any concern at all when we were members of the EU, but now much more significant restrictions on what can be done in terms of cabotage for road haulage, and there's no agreement on cabotage for maritime transport services, because that's a matter for member states. Again, highly sector specific and complex. I should also mention that the rules, so far as they apply to Ireland, are not always consistent with how they apply as between the UK and the rest of the EU. And again, if you have particular questions on these issues, then we can attempt to answer them. However, let us move on to reminding you that we have another event on the 18th of February, as I mentioned, and I am hoping, and I can see it, that the link has now appeared in the chat function. So if you do want to sign up for that event, please do. In the meantime, we are ready, willing and able to take questions, and I have spotted two so far. neither of which I suspect we're going to be able to answer. So the first question which I will take is a question about the UK government offering financial incentives for EU citizens to leave the UK. And the question is, I wonder what you think about that. Well, I think many things about that, but I am not at liberty to say what I think, because that would get us into the kind of political hot water that we have studiously tried to avoid in this debate. I imagine that the UK government's perspective on this is that the UK government is taking a very strong line that all non-UK nationals are non-UK nationals and are to be treated in broadly the same way, and EU citizens are in no different position from other non-UK nationals. And that's probably as much as I am going to say on that topic. Charles, you've got an even more challenging question, I think, which is, if I can paraphrase, what would we say was the wisdom or otherwise of the UK giving up leverage by giving more flexibility to the inward flow of goods from the EU than is being given back to it, and there is specific reference to what's happening at the borders in terms of inspection of seafood and the impact that that's having on the seafood industry.
Yep. And I'm tempted to fake further technical difficulties, but I'll do my best. Yeah, I mean, I think it is striking that all of the flexibility is being offered on the UK side. It's not necessarily all that surprising. The EU is not a very flexible organisation, particularly when it comes to its rules. It's pretty hard to change them, very hard to get them to make any exceptions to them. I think it's probably a reflection of commercial reality, in that if the UK were to put up too many barriers, too many immediate barriers to trade from the EU, I think the UK would probably start to suffer shortages of key goods and inputs in a way that the EU doesn't necessarily suffer shortages going in the other direction, because the EU has sort of many more potential sources of supply internally. I think it does, to some extent, it does illustrate that the EU, it's not easy to do business with or in the EU from outside the EU. I think the difficulty of that we probably didn't perceive while we were inside it. No doubt there are people and businesses in other countries, other non-EU countries, who will now be saying to the UK, you see what we've been talking about. I think the EU does take a very strict approach to letting things in to the EU, even though it's then very free in how things can circulate once they are in. So I think it's more a reflection of that reality of supply chains, that the political pain would be felt by the UK government, probably more political pain if they introduced restrictions that stopped the EU getting EU goods getting in, than they do for allowing that to continue when UK businesses are having a hard time from EU officials. And obviously, it's only fair to say that some of the difficulties are self-inflicted to some extent, that UK government procedures are not necessarily in place. But stories like ham sandwiches being confiscated from British lorry drivers by Dutch border officials, I think don't help with that perception of unfairness. And I can see that those who are at the sharp end of it will feel that it's particularly unfair that there isn't the possibility of retaliating, or even just the schadenfreude of misery loves company approach.
And our very last question, Charles, which is, if we were gamblers, how long would we bet it will be before the UK goes back into the single market?
I wouldn't bet any money on that. I think people are. It's kind of a psychological thing that once people have committed a lot of costs to something, and that might be money, it might also just be the cost of hassle. they are reluctant, particularly reluctant to show either to themselves or to others that that cost was wasted. So it's kind of, well, however you perceive it, you could think about it as a gambler chasing losses, or you could think about it as having invested in a new approach, you wouldn't go back on it. So I wouldn't bet any money on that, actually.
And I would only finish by making the provocative comment that the answer might be different depending on which part of the United Kingdom we are talking about. So that is enough from us today. Very grateful to people who have stuck around for the whole of this session. Thank you very much for attending. Please, please do come back to hear people far more interesting than us in February talking about the impact on their sector of what has been happening, and we will see you then. If you do have additional questions, please drop us a line, one or other or both of us, and otherwise we will see you in February. Thank you very much. Good afternoon.
Thank you.